Jens-Uwe Franck, very well welcome to Digital Markets Research Hub. Many thanks for your availability. You have recently published two very noticeable pieces. One just the final version of which published in Common Market Law Review, and another one is, both are available on SSRN as pre-final versions. One is co-authored with Martin Peitz, your colleague from Mannheim, and both address very topical issues on the emerging regimes. The first one on the DMA, and another one on Section 19A of the German Competition Act. So I wanted to use this rare opportunity to meet you in person, one-to-one, one-on-one, and to discuss both of these papers, or maybe rather ask you to present the details of those papers, because they are really topical and they are very original and thought-provoking. So the first one addresses the phenomenon which appears to be very new for competition cluster of EU law, but it is apparently not very new as such, the anti-circumvention provision, and you engaged in very detailed elaboration of both conceptual but also practical implications, with very vivid examples from the DMA of this new provision, how it will be applied, etc. So I propose we start with this paper, and yet as the very beginning, maybe it would be more helpful for us to understand the way of your reasoning once you do this intellectual disclaimer, somehow identifying your normative position about both emerging regimes.
Yes, first of all, thank you very much for this kind invitation and for having the chance to basically present those two papers here. And of course, thank you also for that rather flattering introduction. Yeah, speaking about the DMA, but also 19A in a way, 19A, so Section 19A, this section or provision in the German Competition Act that is like a functional equivalent to a certain extent to the DMA, just for like listeners who are not familiar with the German developments. So, I mean, there's nothing original to say that these are products of a common feeling, understanding that the conventional competition enforcement is in certain ways, was in certain ways inadequate to cope with the challenges that come with, let's say, big tech, so large digital gatekeepers, especially in terms of institutional design, but also in parts in regard to, substantive issues. I think what I would need to emphasize, what I would like to emphasize is, so this perception of a huge asymmetry between big tech on the one hand and the competition authorities on the other hand. So, and I mean information asymmetries. So basic things like, what's the business model? How does it work? What are like the monetization strategies, technology? And also, of course, I mean asymmetries in terms of resources, right? So basically the sheer amount of resources that is at the disposal of big tech means, well, let's say it helps a lot of getting their interests represented. And so that's, I guess, one important general factor behind it. And then if we speak about normatively more substantive adjustments, we see in a general way, I suppose, I could mention like two aspects that stand out. I mean, if you see like the standard competition policy and enforcement, so usually, not always, but usually we are indifferent in regard to how rents are distributed up the supply chain between various suppliers. There are exceptions. Think about the agri-food supply chain, at least in Germany. We have also like practice there that clearly has the intention of, shifting rents towards the primary producers, the farmers, basically. But these are exceptions. Usually, competition enforcement is indifferent. That's really different here, right? So we see that a clear policy objective is to have like a fair share of rents for the sellers, that is the business users of the platform. So you really want to shift rents from the platform operators to the sellers, business users more in general. By the way, that's not really new about the DMA, for instance. We can see it also in regard to specific regulatory interventions by some member states. Think about the prohibition of parity clauses, specific prohibition of parity clauses in France, Belgium, Italy. And so this was clearly also addressed to shift rents from the OTAs, Booking.com basically, to the hotels, or think about the so-called Lex Apple Pay in Germany. So this was also about, not only, but also directly about shifting rents from, let's face it, Apple to German banks in this case, right? So, and this is really conceptually new here. And the second point, I think, which is important to keep in mind, is competition enforcement usually has like a, well, it's a challenge, let's say, this way to competition policy, if you have divergent effects of a specific policy on different user groups, right? So it might be that a policy of a operator of a platform might, in the short run, be beneficial to the end consumers as a user group, but not really beneficial to the business users as a user group. The long run, again, might be different as well. So in competition law, usually we try to avoid netting of, you know, various effects on various consumer groups. It's never really, you know, strictly impossible to net those effects in competition enforcement, but we try to avoid that for, I suppose, plausible reasons. And here, obviously, if you have like an act like the DMA, who has more or less specific obligations, it's basically the legislature who makes that choice, right? So in case there might be implicitly at least some trade-offs here between end users and business users, and by having a specific rule, the legislature makes that choice. And that is also, I think, like an interesting conceptual novelty in a way, if you like, or progress, depending on your position on that, to competition enforcement.
So maybe we can start with looking at the paper, the first one published in the Common Market Law Review, the Digital Markets Act and the Whack-a-Mole Challenge. This very colorful metaphor somehow catches the imagination, and it's very accurate metaphor in many respects. So it was somehow it becomes almost a very popular way to interpret this anti-circumvention provision. So before looking at the paper itself, can you maybe provide to us some outline about the very phenomenon? Is it a new phenomenon in EU law? Can we trace its pedigree from other areas of EU law? And if it and does it matter, or it will be a new start?
So that's like a question about this regulatory technique, having like a specific anti-circumvention provision. And indeed, we find it in the law. I mean, it's very prominent, for instance, in those sanctioning rules or instruments, which has been, adopted by the EU. So there are explicit anti-circumvention provisions, but also, for instance, in consumer protection law. At the EU level, for instance, there we find only in specific cases this kind of provision. Interestingly, for instance, the German legislature has opted to have it more or less across the board in consumer protection law. So in that sense, you're completely right. So it's not a new phenomenon having this. And does it really, or what way does it help? In interpreting what we have now, the DMA, well, basically, we use it to make one argument or to substantiate one argument that is no need to implement, or there's a good argument to be made that there's no subjective element, not implicitly in that. Because in other situations, you have like on other contexts, you have like an explicit subjective element there in it. So, but otherwise, what we did not do actually is looking into the actual implementation. But apart from that, I mean, even in certain situations, of course, where we don't have this as a regulatory technique, you find it, of course, as an argument in, judicial rulemaking, right? So we find like similar arguments when it comes to the market freedoms in certain contexts, and also in regard, for instance, speaking about other provisions like 157, so equal pay, TVU, equal pay for men and women. So they have a kind of like equivalence test developed by the court there. So you can see the general idea, the general concept is, of course, not a new legal concept as such.
Great. Okay, let us move then to the paper. Motivation, objectives, main messages.
Well, I mean, so in terms of motivation, when Martin Peitz, so this is co-authored by Martin Peitz, as you have mentioned, so he's an economist. When we debated the DMA a lot, of course, during the last years. So, and if you see the regulatory approach of the DMA, which is basically trying to create more or less precise do's and don'ts, and then simplifying implementation by that. So that's, I suppose, the basic idea of having this regulatory technique. Well, then the obvious question is, what do you do in situations where the gatekeepers who have like strong incentives to try to re-establish the economic situation without intervention? What if they do that? They find ways to change their behavior, but coming up more or less with the same outcome, but this activity might not be covered, not be captured by those specific rules. That's obviously like an obvious problem, right? If you have this kind of regulatory technique. And so from the very beginning, the discussion was about how to future-proof the DMA. And if you see other instruments there, sure, the Commission can adopt delegated acts. The Commission can then also propose to, introduce new obligations. But that is, on the one hand, it's, of course, you need resources for that. You will have a time delay. But then even if you think that's true, well, then you have new obligations, you have adapted obligations perhaps, but then this might only start a new rule, a new circle that the gatekeepers start to circumvent this new rule, right? So, and that's why we think this anti-circumvention provision we find in the DMA is really crucial to, well, not just to say to future-proof the DMA, but to understand the concept behind the DMA and how it might really work effectively. So we thought it's very interesting to try to think about how to make this work in practice, how this could work conceptually, as you said, but also, to use specific examples to try to show what it could mean. And what we, in terms of, methodology, what we tried was look into the past. We had like specific, incidents where competition authorities were actually enforcing competition law, and also one way or the other creating specific rules. For instance, the prohibition of parity clauses, also of like strict parity clauses done by the Bundeskartellamt, or for instance, the intervention by the Dutch competition authority against Apple, against the bundling of the App Store with the payment mechanism by Apple. And just look at this and see what kind of reactions we have then by the gatekeepers, right? And we can use that. We try to use these kind of examples now to think about how we could use and what could the anti-circumvention provision actually mean from the Commission's point of view, basically, when applying this provision in the DMA. And yeah, so that's one point. Of course, that's like gives us like the view on how like a specific legal provision might work. On the other hand, of course, I should add, from a conceptual point of view, of course, it's also very interesting. I mean, if you start thinking about circumvention and possible reactions by the gatekeepers, that of course raises also the general question, what can you actually hope for in the long run, right? So how effective might the DMA really be in terms of like the overall goals that come with the DMA, right? So that's also, I think, an interesting facet if you start thinking about circumvention.
But also, among other implications which the paper elaborates, or the arguments which the paper elaborates leading to implications, is that the provisions of Article 5, when applied in conjunction with Article 13, by means of Article 8.2, the Commission can issue specification decisions, or implementing acts, which somehow opens the door to the argument present during the very beginning of the DMA discussion, or links it to the argument whether the DMA can be applied in without looking at the effect-based approach somehow. Is it possible even to try to make it purely without engagement of economists, let's put it this way? Can you please elaborate on this part of the discussion?
So on the one hand, it's just an interesting observation if you look into the DMA, that, as you have mentioned, if you have like Article 5 obligations, they can as such not be, clarified by implementing acts, whereas if you have Article 6.7, Article 8.2 applies, you can have implementing acts. But if you're thinking about anti-circumvention, then it is specifically mentioned in the DMA also in regard to Article 5, you can have implementing acts, right? It's just an observation. So what is behind this? So probably the assumption was, generally spoken, that the obligations in Article 5 are by themselves already clearer and a way more precise than Article 6.7. But if anti-circumvention comes into the play, it's not so clear anymore, right? What is captured. So then the Commission should have the rights, the competence to issue these implementing acts. Now, I mean, speaking about like affects, based analysis, I think still it's true. The basic idea of the DMA certainly is and was to try to avoid this, to lower implementation costs, to make interventions swifter, basically. First of all, if you look into the list of Article 5, you will find, however, that there are certain provisions. For instance, the obligation that the gatekeepers are not allowed to impose a parity policy, that are really phrased in an affects-oriented way, interestingly. If, for instance, you compare it with what certain member states have done about this, right? Look at the legislation in Italy, for instance, it more or less says parity clauses are prohibited, right? I mean, there are nuanced differences, but basically this is that. While if you have a look into the actual wording of Article 5, third paragraph, it's basically, so I have the text here. So if I want to quote the wording, I should indeed quote it. So there the wording is, the gatekeeper shall not prevent business users from offering the same products to end users through third-party online intermediation services at prices or conditions that are different, and so on, right? So shall not prevent is, of course, already like an effects-oriented language in a way, and also if you compare it with the recital to that, so it tells us, so this is not just about specific clauses prohibiting a parity policy, but it's already effects-oriented, right? But I mean, of course, if you go through the whole list, that might be rather the exception. But we will see. I mean, I'm not a specialist on any kind of obligation that is in the provision. But having said that, of course, we still believe, and it's not the idea of our paper to, to bring in through the back door an effects-based analysis to the actual obligations that is not already there. So let me clearly make that point, right? So we clearly accept that regulatory technique approach by the Commission. We just notice there are certain provisions, such as Article 5, just quoted, where you have already a certain indication of an effects-oriented analysis. But generally spoken, our main idea is really this anti-circumvention provision is meant to safeguard the regulatory technique in the original provisions. That is different. That at least as a baseline tries to avoid the effects-based analysis. But of course, we argue if you want this anti-circumvention provision to work effectively, you definitely need to have effects-based analysis. And we think this is also clearly intended by the legislature if you read the provision, you read the recital, and so on. And well, some would say, unfortunately, be it as it is, but it might help to have some economic analysis here.
Extrapolating this state or this proposition to the discussions within which we have within 102, do you think this would somehow limit the discretion of the Commission, or what would be the role of judicial scrutiny of these provisions? Would it depend whether the case, the decision is made in conjunction with anti-circumvention provision or not, and maybe more generally?
So, okay, these are various questions in a way, right? So, first of all, I guess one answer is, what is like still the difference between what we propose, the effects-based, approach to anti-circumvention, and perhaps like those cases, it's not always, of course, but those cases under 102, where you need to have really like a detailed effects-based analysis. And of course, to be sure, and that's really like our main argument, basically, right? So we have like a 3-step test. So basically, we are saying if there's a suspicion that a certain conduct could be an circumvention, first of all, you got to be clear about if you have this specific obligation, be it the provision of price parity, be it something else, what is the intended effect of this specific obligation? So we have the overall objectives, so fairness, contestability, and of course, somehow the legislature must have imagined that this specific obligation serves those overall purposes. And in the first step, you got to think about, well, how? What is the intended mechanism, the intended effects of this specific obligation? And here, of course, on the one hand, this is just, normal interpretive work. As a lawyer, nothing new really, right? So you look into the recitals, you look into the materials for the legislation. But also what might help is not all of those provisions, but a lot of those obligations. I mean, where do they come from? Well, they come from competition enforcement in the past, sometimes perhaps from failed, whatever is a failure, competition enforcement, and are meant as a reaction to that. That might also help to interpret what is the intended effect by this provision. So this is the first step. And here, I mean, of course, some economic analysis might come in, but just, not like empirically, just about like what is the economic logic perhaps sometimes behind a specific obligation. But then we say in the second step, then you have to look at this practice that is suspicious of being a circumvention, what is like the effect there? And then as a third step, you get to compare, is there like equivalence as it is as it is necessary under the anti-circumvention concept, so that you can call the behavior that you have, that you have checked and circumvention. And of course, this is basically also like a normative exercise, because you will never have an effect that is one-to-one under all circumstances has the same effect, obviously. So what about this delta? How big can this delta be? And that is then, first of all, of course, the question to the commission. But then, as you have said, later on, we will have judicial review. It will be on judges ultimately at the ECJ to decide how can you apply this anti-circumvention condition, and what does equivalence in that context really mean. I hope this, to a certain extent, at least answers your question. So, because it should be clear that if you compare that to, I don't know, effects-based analysis of 101 or 102, still, this is only, if you like, about trying to extrapolate the idea, the objectives as they are enshrined in a specific obligation to other conduct. It's not about bringing in like a more or less fully fledged welfare analysis or something like that. Not at all. It's really specifically about this mechanism that, from our perspective at least, the anti-circumvention provision has in mind.
Another question is somehow related to this one, is the relationship between between circumventing the obligations and the very fact that the non-compliance. You propose the logic under which the anti-circumvention is not an autonomous instance of some delict, or it's not a violation in itself, and thus you cannot impose fines on the attempts, or rather on the reality, or on the actual circumvention of obligations. Maybe can you elaborate, does intent matter, to what extent, what is the conceptual links between the obligations 5.7 and Article 13?
So, I mean, again, these are in fact various questions, right? So, let me start by the intent question. So this is, from my point of view, basically a question of interpreting Article 13, 4th, 6th paragraph, right? I should mention the 4th paragraph is like a general anti-circumvention provision. The 6th paragraph is more specific, mentioning certain behavior like degrading in response to certain behavior by the business users. So in my view, this is a question of how to interpret this. And first of all, if you look into the provision, you look into the recital, you look into the materials, no subjective element is mentioned, no element of intention. While, for instance, as I mentioned before, if you have like other acts, so for instance, you see those sanctioning against, third countries, for instance, issued or adopted in the context of the war against Ukraine, there they can see there's specifically a provision saying you need to have the intent to circumvent. So this all together brings me, or brought us, to the conclusion there is no subjective element intended by the legislature. So in a way, which also makes sense, because if you want this to be effective, it's not, you can't say that why should there necessarily be subjective element. So we are thinking really you should take the legislature here at its word. It's as such, whether or not objectively there's a breach of the DMA, you can say that without, referring or attributing like a subjective element to it. Having said that, of course, it means if you look into specific sanctioning, then of course, in particular, if you think about fining, then of course, subjective elements necessarily come in, because you can only be fined if you acted negligently or with intent. So then, of course, first of all, is the question how these sanctioning mechanisms actually step in if you have a breach of the anti-circumvention provision. And secondly, then the question is, what does negligence, for instance, mean in that context? In regard to the first question, of course, things are not so obvious. Why are they not so obvious? Is because if you look into the DMA, right? So into Article 29, but also same if you look into Article 30, you will see anti-circumvention is not mentioned there, right? So you have Article 29, first paragraph, non-compliance. This is about breach of obligations 5, 6, 7. And then you have also obligation under Article 8, second paragraph. That is, you have an implementing act. And if they breach against that, the Commission can go for non-compliance, the same with fining. So if you see that in isolation, and that has been argued in the literature, okay, that probably means if you have a breach of Article 13 and the circumvention, this can only be sanctioned or enforced, publicly enforced by the Commission after there had been an implementing act under Article 8, second paragraph. That has been a conclusion made in literature. Now, we think that is not correct. Why is that not correct? And now things are getting a bit difficult because, first of all, generally spoken, why there's room for interpretation here? Well, because you can read Articles 5, 6, 7 in conjunction with Article 13, 4th and 6th paragraph as saying this anti-circumvention provision extends the scope of the actual obligations in specific context under certain requirements. So then you can, of course, read, if you follow this train of thought, you can read Articles 29 and 30 as saying also implicitly, if you have a breach of Article 5 in conjunction with Article 13, then public enforcement applies. A more technical argument is, of course, if you have a look into Article 13, there is a specific provision. That's the very last provision there, and that is the 8th paragraph. And here things are getting a bit complicated because Article 13, 8th paragraph, hold on for a second, reads paragraph 6, and I come to that, is without prejudice to the powers of the Commission under Articles 29, 30, and 31, basically public enforcement. And when I read this for the first time, I was thinking, why paragraph 6? What is the meaning? Why should ever specifically paragraph 6 be of prejudice to public enforcement? It doesn't really make sense. So what I did was, so I looked in the 4-column document, which was published by the Commission after, in March 2020, after the trilogue negotiations, the final compromise was reached. And the numbering was different there, but there it becomes pretty clear. You have like the corresponding provisions there, and there the reference in what is now Article 13, 8th paragraph is not to paragraph 6, but to paragraph 7. Now, if you look into Article 13, paragraph 7, this is the very provision that gives the competence to the Commission to adopt implementing acts. So what does it mean? That gives a completely different meaning to Article 13, 8th paragraph. It means the right of the Commission to adopt implementing acts in case of anti-circumvention should be without prejudice to the powers of public enforcement. And that, if you like it or not, but it makes sense. While this reference to paragraph 6 doesn't make any sense to me, at least, at all. So that's why we thought that should be read as a editorial mistake. So it gives us like a clear indication then, if you buy the argument at least, that the legislature had in mind there can be implementing acts in case of anti-circumvention, but this is not a necessary requirement for public enforcement. This answers the first part. The second part then is, well, if you generally spoken have no intent, there's a requirement there, and if you can have direct public enforcement without having an, implementing act first, is this all perhaps too uncertain? Especially when it comes to fine, right? So because there's like the strictest standard, this is quasi-criminal liability. So from a constitutional point of view, I guess everybody agrees there's a strict standard. And in particular, I think there's an agreement there. We have also ECJ case law from very different, contexts that, for instance, you cannot establish an obligation by analogy as a judge and then find this practice. So you might ask yourself, so isn't this what happens here, right? So you create obligations by analogy and then you're finding this possibly. And I'm saying that there's a big difference between those situations that are not allowed under like general principles of fining, because this applies only to situations where you have in the law the actual obligation, and then a judge comes, draws a conclusion by analogy, and then fines. But this is different if you have a specific provision, an explicit provision in the actual, here, the DMA, in the act, saying anti-circumvention is prohibited. Sorry, circumvention is prohibited, so anti-circumvention is illegal and can be fined. This is different. So this general idea, for instance, that you can not find behavior that has been established as illegal only by analogy, this does not apply here in this context. So we are here really in a different scenario where you basically have like a general clause or general clause-like provision. And you might ask yourself, is this too uncertain to find ultimately behavior that ultimately a court finds this is a breach? And here, our argument is, in fact, the kind of analysis, effects-based analysis we have in mind for identifying circumventions that are actually captured by this provision is by generally spoken at least, not more uncertain than, for instance, an effects-based analysis under 102, for instance, where also like the Commission is free to develop new theories of harm. Think about the Google shopping case. And you might like it or not. Some lawyers don't like it, but the Commission nevertheless, has apparently not hesitated to impose quite a high fine. Even though some would say, from an ex-ante perspective, it was maybe not so clear that this is illegal. So just taking this standard, which apparently their finding is accepted, and you apply this standard now in this context, I would argue, generally speaking, there's probably no problem, generally speaking, with finding breaches of anti-circumvention provision, even in situations where you have no implementing act that comes first. Having said that, so of course, I think we make the point in the article, there might be exceptional circumstances, there might be individual cases. I don't know how the Commission will apply the anti-circumvention provision in the future, where you can bring forward the argument. So this was really too uncertain. We could not have been foreseen that this is illegal in individual cases, perhaps. But generally speaking, I don't see a problem, if you like, here.
Many thanks. And what would be the situation with private enforcement? We understand the direct effect, we can agree or disagree, but this is a well-established practice and rationale of EU law is there. So private enforcement will be there. But what about, can the private parties refer to anti-circumvention provision?
So private enforcement is, of course, quite interesting, right? From various perspectives, right? So, and basically, if you see the just in terms of like doctrinally, right? So what are the requirements? First of all, you need to have like implicit rights. And without going here into detail, also in the article, we elaborated a bit more about that in the first version. But for the ultimate article, this was shortened. We just assumed, and I think it's not very contentious, that those obligations on the gatekeepers, if you see all the arguments that have been used by the ECJ in various contexts, they convey implicit rights. I suppose it's not very contentious, but in the article, we left that short. Okay, having said that, of course, then first question is this unconditional? And now, of course, we come back to the discussion we just had. So if you assume that, for instance, public enforcement is only possible after there had been an implementing act, if you read articles 29, 30, and article 13 this way, you might make an argument that this is not really unconditional. But as I've just said, that's not our reading. Our reading is you don't need an implementing act first for public enforcement, therefore also for private enforcement, the more so, I would argue, so that should be read as being unconditional. So then I guess there's more or less like a third step. You got to think about what about, is that clear and precise enough, that implicit right, that comes from that obligation. And here again, if you just have a look into the case law, of course, in other contexts, by the ECJ, I would say, well, the ECJ usually is very generous here, So for instance, it seems to be though that the ECJ was not hesitant at all to attribute direct effect to 101 and 102. Here again, I would make the argument, so this kind of affect-based analysis we have in mind is not really more uncertain than the kind of affect-based analysis, at least in certain circumstances, you need to have under 101 and 102. Similarly, I also mentioned that in a different context, if you see the case law on Article 157 TFEU, that is the equal pay provision, so there's an equivalence test here. The ECJ was not hesitant to say there is direct effect. You can apply that, you can invoke that horizontally before a national court. So generally spoken, I think I would be optimistic, of course, depending on your policy perspective, but that the ECJ would not be hesitant to say this is clear and precise enough, So the basic values behind it are given by the legislature that can be applied by courts, and there is direct effect. So that's the argument we make. I'm relatively sure that this will prevail ultimately. Of course, from a policy perspective, and I know that you are skeptical about this, you might think it's maybe not so perfect that we have like private enforcement just like that. And it might be that even the Commission is not too enthusiastic that all what the Commission does and negotiates and the dialogue with the gatekeepers can relatively easily be overtaken by a lower court somewhere at the European Union, which, I don't know, issues an injunction just like that, perhaps. But that's, of course, it's a different policy issue, So in that paper here, we just, try to make the argument that if you see into the whole machinery of public enforcement and private enforcement in the DMA, from our perspective, there's probably not much of a difference, from a general perspective at least, whether you have an infringement of Articles 5, 6, 7 as a standalone case, if you like, or seen in isolation, as compared to an infringement of Articles 5, 6, 7 read in conjunction with Article 13, 4th and 6th paragraph. And that's our, well, if you like, legal analysis starting point also in the paper.
Also, you offer a three-step approach for scrutinizing the conditions for anti-circumvention. And in this regard, you mentioned inter alia that the link of the DMA's overall objectives needs to be elaborated. How did the legislature envisage the obligation promoting contestability and or fairness? So I wanted to ask maybe a broader question. Do you think that when interpreting the non-compliance with obligations, the Commission will be expected to build the links between the obligation compliance or the scope of obligation and how this obligation itself contributes to or protects maybe fairness and contributes to contestability? Would the situation be different if they would be applying, if they will investigate in the case in conjunction with anti-circumvention?
So I think the clear answer is when you, as the Commission, the same if you are judge in private enforcement, if you apply directly those provisions, basically I see no specific need to always come up with a theory of harm or something like that. No, not at all. That's not the idea. Of course, these factors, how this specific provision or this specific obligation is linked to the overall objective, might be an argument also in isolated 5, 6, 7 cases when you argue about how a specific element there should be interpreted. Clearly, but this is just the usual interpretative work that needs to be done by a judge or by everybody who basically applies it. But there's certainly, I think, no need to come up with a, however you characterize, however you describe this, that this specific behavior, let's say in a situation that is clearly caught by the provision as such, in this specific situation can actually damage contestability or is unfair or something. No, no, I wouldn't say so. So there's no need for that to be done. Only as like an interpretive mechanism, you might, that might be helpful to have this as an argument, but there's no need to have this. So I think at this point, really the regulatory technique, the approach is clear. So this, I think, is really different when it comes to anti-circumvention. And that situation, that at least our reading, I'm pretty much sure on that point this is correct. You need to make up your mind about what is the mechanism, the intended effects of a specific obligation to somehow, consistently make up your mind about, is this what you see as circumvention or not, right? So I would presume, I don't know, I mean, perhaps if you look, you read this in the article, our 3-step test, maybe the language is very, we elaborate a lot about this. This is very detailed and so, but at the end of the day, I think, as I explained before, it's a relatively straightforward approach. And I think even if you take, if then later the Commission takes a shortcut at some point, I think always implicitly this kind of thinking we try to make explicit here will be also in this shortcut. But basically, I think what we have in mind, I think probably that's important to make this point. It would be naive to think about circumvention in terms of, I don't know, a sequential follow-up of events, right? So like the DMA comes into force, the gatekeeper implements, and then the gatekeeper, circumvents. Okay, now this is a circumvention. That would be very naive to have such an idea in your mind. So you really need to think about like some kind of affect-based approach, right? So of course it can be that there is behavior that has been there before that can be characterized as a circumvention. And of course there can be behavior that is or seems to be a causal reaction or a reaction caused by implementing the DMA or looks like caused, but it might be just be like a dynamic amendment adjustment of the business model of the gatekeeper. So really, at the end of the day, if you want to have like consistent, idea about what is a circumvention, if you have in mind this anti-circumvention provision is about maintaining, safeguarding what is the actual gist of a specific provision, you cannot do so without this kind of or similar kind of analysis, we believe.
Before moving to the second paper, the last question on the first one, reaction. It was very visible, people discussed the things. I imagine you received feedback, formal and informal, collegial feedback from different peers. Can you summarize it somehow?
So, I mean, first of all, I should emphasize how we had the chance to present that paper at various conferences and so on, received a lot of, academic feedback, which was, enormously helpful. We mentioned this also, like, at least in part in the footnote at the beginning. So this obviously there were some policy issues, but a lot of, also about like technical issues, and also the peer review was very helpful. So having said that, of course, first of all, there are no specific reactions from the part of the Commission, for instance, apart from the fact, so they appreciated that people are thinking about this and saying we are also thinking about this. And also, I have no specific reaction in mind from representatives of the gatekeepers. So having said that, what is interesting, we got like, for instance, feedback by, a couple of lawyers who are more on the side of the, well, let's say on the other side, right, of the players who, you might benefit from having like tougher obligations on the gatekeepers. And for instance, we got a comment saying, well, they don't like where we actually, draw a line, draw a boundary. Basically, I should make this point. Of course, thinking about anti-circumvention, this is really thinking about what are really the outer limits of the DMA. And now what we are saying, like our general point is really, if you have a situation where the gatekeeper, substantially adapts the business model, the monetization strategy as such, as a reaction to what we see in the DMA, obligations, restrictions there, it might be that this has, in certain situations, similar effects on the distribution of welfare, for instance, of those obligations, or those obligations try to avoid. Nevertheless, we are saying this is then really on the other side, right? This cannot be captured by anti-circumvention. To make an example, so think about like Amazon Marketplace. Obviously, they have like a monetization model which rests on having fees on the one hand, but also making profits by products they are selling on the marketplace. So self-preferencing, of course, helps there. And if you take away the self-preferencing as an option, so they will make less money there on this side. So the overall strategy might be having higher fees, generally spoken. Could be, I don't know. So it might be that at the end, the overall effect intended perhaps of, shifting rents from here to there might be also undermined by this kind of reactions. But our argument would be, this is then like something new you are facing as a regulator. It's really like a new situation, and you should decide whether you want to engage in that kind of regulation, especially when it comes to fees, right? So this is that would then really like a more or less free flow price regulation you would engage then in this context. And what would be like the counterfactual scenario? It's really unclear. The yardstick is unclear, and also generally speaking, I think this would be beyond the mandate of the Commission. But that has been criticized. But just to clarify this point, I mean, we are not saying that price-related conduct could never be a circumvention. Certainly it can, right? So if, for instance, you have like a seller, a hotel, for instance, or like a seller on Amazon Marketplace that uses the freedom it has as price parity policy is not allowed to sell cheaper somewhere else. And now, if now the gatekeeper would individually raise prices to punish this seller, of course, that can be, you know, a circumvention strategy that can be punished, right? But these are like different scenarios. And we also have like other examples in the paper, for instance, you know, about bundling, how margin squeeze could come in, you know, for instance, if you think about like Apple now giving the option to the app developers having, you know, competing suppliers for the processing of payments. So then the fee is reduced. And what about if this reduction is not sufficient to cover costs of an alternative payment mechanism? Here again, there can be, you know, also that this is margin squeeze, and it could be that this is a circumventing mechanism. We're not, you know, excluding this generally, but where you have really adaptation of the business model, the monetization strategy as such, I gave the example. So that's at least our understanding. That cannot be captured anymore. So that has been one response of those who would like to see, you know, the DMA going further. Just to mention perhaps like a small point at the end, my feeling was also that a couple of people who, generally spoken, are very much in favor of the DMA, they didn't like really so much our analysis, because in a way it makes clear that circumventing strategies will be everywhere probably, and it really raises doubt about whichever you approach will be on a circumvention, but it might raise doubt about how effective the DMA will be over time, especially when it comes to this fairness objective and about the idea of shifting rents here from the platform operators to the business users, right? And I think, but of course, this is just, you know, don't shoot the messenger, right? So this is just our analysis here.
Many thanks, Jens. Let us move to the second paper, namely the title of which is Abuse Proceedings Against Digital Gatekeepers under Section 19A of the German Competition Act, taking stock of early results. The first question is obviously, remind us please the rationale and the key elements, and maybe in comparison to the DMA differences of the provisions of Section 19A.
Thank you. So first of all, from a very general perspective, as I said before, this really needs to be understood to a certain extent as a functional equivalent to DMA. It came first. So the idea probably also was in a way that the German legislature, by introducing like a new instrument, even though as part of competition law clearly, want to encourage the EU legislature to really go down this road to have like a new instrument, also in regard to the, you know, digital gatekeepers at the EU level. In that sense, I think the German legislature considers itself, you know, successful, right? So what is different about 19A is, very generally spoken, as I said, is an instrument of competition law, of competition policy. In a way, the DMA you could also think is an instrument of competition policy, but here it is clear it's competition law. By the way, also within the definition given in the recitals of the DMA. Insofar as you have, like, at the end of the day, you have a case-specific application of those rules. Also, you have like the chance for the gatekeepers to bring up, you know, efficiency defenses, and you end up having like a balancing exercise, as you might have it also, especially under 102 or equivalent provisions under national law. So in that sense, this is still competition law, but the institutional design is different from, you know, conventional 102 or similar provisions under under national law. So basically what you have is a two-step activation design, I'll call it here, meaning you have first a designation decision. That is really similar to the DMA. So there are certain criteria which are qualitative criteria. That's different to the DMA, no quantitative criteria, under which the Bundeskartellamt, the German competition authority, may designate certain players as, I just call it 19A addressees, right? So there's like a technical term here, doesn't make sense to translate it into English. Let's just call them the 19A players or 19A gatekeepers, whatever. And is that meant to target only digital gatekeepers? Well, that's definitely the intention by the legislator, has been the intention. Even though it's fair to admit, if you look into the criteria, the basic criteria really is about that you're operating a platform, and in particular, network effects are very important there. So basically, it's in theory, I mean, any kind of operator of a two-sided platform could fall into this. Who could that be? I mean, you know, beyond digital business models, well, it could be, you know, credit card systems, if you don't call them digital, in theory, but I think that's purely academic. It could also be like, I mentioned this as an example, like an international hub airport, like Frankfurt, for instance. But as I said, that's probably just theory. This is meant to address the large digital gatekeepers, and which is relatively clear from the legislative materials we have, even though the criteria are open in a way. And so far, I mean, I can make this point. So they are like 4 gatekeepers that have been already designated. So these are like Amazon, it's Apple, it's Meta, and it's Google. And there are ongoing procedures against Microsoft. Google and Meta have accepted designation, so no appeal. Amazon has appealed. They just yesterday or day before yesterday, they lost before the Bundesgerichtshof, the Federal Court of Justice, and Apple has also appealed. We will see what comes out from that. And then, so you have this first phase. So this is designation, and then what is different to the DMA? Then you have 7 categories of behavior listed there in that provision, but it's not that automatically these would be obligations of designated gatekeepers. It's only that in the second phase, the Bundeskartellamt has discretion and has the right to impose certain obligations which are listed there, usually in a more general way, that obligations drafted in a more general way than in the DMA on those designated gatekeepers. But sometimes I think there's a misunderstanding in the international community about this. This is not just like a tick the box approach, right? So it's not just you're designated and we impose on you like the provision of self-preferencing. That is really, the Bundeskartellamt needs to apply this as similar to an abuse procedure. That is, there need to be a specific case, there need to be conduct, which is actually already there, or can be also that like a competitor or like a customer complains that there might be in the future certain conduct, or the Bundeskartellamt might have seen that another gatekeeper engages in certain conduct that might fall under this, and they need to make a case in that specific situation, and the gatekeeper can put forward efficiency considerations, objective justification is it called in the provision, and as I said before, there need to be like a balancing exercise. What is different also to normal abuse procedures is, so to make that faster, there is a bridge judicial review. So if there's a decision by the Bundeskartellamt, you have just one shot, appeal to the Bundesgerichtshof, the Federal Court of Justice. And in regard to, let's say, generally speaking, normative statements about how to apply that in specific cases, the legislature made it clear there are certain adjustments to like the normal abuse proceedings. In particular, was the legislator was clear about the Bundeskartellamt should have like the right, the option for like to take into account more long-term effects, even if they are like more uncertain, right? So if you speak about long-term versus short-term effects, there's like the option for the Bundeskartellamt to openly put more normative weight on long-term effects, even if not so certain, right? So meaning also like, if you think about like the application of abuse proceedings as like an error cost trade-off, so my reading would be, it's more acceptable that you have risks of false positives here than in what normal abuse proceedings. I guess that's the main normative changes here.
Before moving to the second part of this paper, where you offer us the exposition of the first cases investigated by the BKA, I wanted to ask you maybe as a follow-up question. We have this discussion in the UK about this the standard of what is called countervailing benefits exemption or efficiency defense in similar structure, not identical though. What is the is it does the BKA has discretion to accept the submission by the parties about the justifying their non-compliance or infringement, and if so, should it be a separate act? Is it justiciable? What is the standard in this regard?
So first of all, it's a very good question. I mean, I should have said this. So there's explicit rule in that provision saying there's a shift of the burden of proof when it comes to objective justification. But it seems clear the moment, so it's a shift of the evidentiary burden basically. So it means the gatekeepers need to come up with, facts basically, facts-based arguments, efficiency arguments. But my reading would be clearly, so if they put forward those arguments, you cannot neglect them. You need to take them into account. There is like in the literature, so there has been the argument, so this shift of the burden of proof should only apply in situations where we have this information asymmetry, meaning if these are really pieces of evidence that are within the sphere of the gatekeepers. So basically meaning that the Bundeskartellamt still has the obligation to take into account effects or possible potential effects that are more or less obvious or that it cannot grasp them easily. So to the defense of the gatekeeper, they need to take into account that as well. So I suppose that makes some sense. Seems to be like plausible to me. I'm cautious whether that really ultimately makes a difference in those cases. But I think overall, the explicit change of the burden of proof means really that the gatekeeper at least is more in a defensive situation in this procedure, in the sense that the moment you engage in a certain behavior that is more or less clearly captured by these specific, specific rules in this provision, you are in a position to really show that this is really the exception, right? So that this is a situation, you need to show this for reasons 1, B, or C. This is a scenario where you as a gatekeeper should really not be, it should not be prohibited that you engage in that specific activity. So I guess that really helps from the perspective of the competition authority, of course, to have more or less of a level playing field, or at least more of a level playing field than in normal abuse proceedings. But I mean, to come back to the original question, and that is really different to the DMA. So if there are case-specific efficiencies, you need to take them into account.
Okay, and the regime is very new, and it's obviously prone to be refined in practice. But we already have some cases, the first wave of cases which you examine in the paper. Can you highlight to us?
So, I mean, as you said, this is in a way, all this kind of analysis about how effective this is or seems to be is preliminary. So we have 7 ongoing, had 7 ongoing abuse proceedings. And so the way I put it in the paper, 2.5 of them has been closed. So there has been 1 proceeding against Meta, Facebook, basically about selling the Oculus glasses. So and here there was like a informal commitment by Meta that you are allowed to use those glasses without having an account with Facebook. So in that sense, this was already a result. In that sense, the case has been closed already. The case is still pending, and so far as the Bundeskartellamt is also saying, the data processing between other activities in regard to Oculus and Facebook must not be compulsory under the terms and conditions of Facebook. This is still pending. So my understanding is they are awaiting the outcome of the old, big, famous Facebook case or Meta case and see what comes out of that. And secondly, of course, it might be also a question of how Facebook reacts to the DMA. So maybe that problem from the perspective of Bundeskartellamt will be solved by DMA implementation. There's a second case. This is the Google News Showcase. So that's a rather broad case. I don't want to go into detail here about this. You can read this in the paper. But basically there is like a couple of informal commitments by Google here, and which are in part really, as far as you can see as an outsider at least, right? Relatively far-reaching. It depends a bit because you don't know what Google first had in mind, really, when they started this policy. What is the issue here? But you can at least imagine that they had a couple of things in mind that they cannot implement now after those informal commitments. Well, does it prove that this is effective? Well, you don't really know, because perhaps they gave up those, this kind of content anyway for like business reasons. We don't know. So maybe it wasn't such a big deal for Google. Maybe it was. We don't really know. It's an informal commitment at least, and it's relatively far-reaching. And then there's a third case. So this is, and there we have like an actual decision, a commitment decision. This is a commission. This is a decision about how you can move around data between various services of Google, and Google basically, so I've simplified a lot, basically agreed here that what is prohibited under the DMA, will also be prohibited under now German law in regard to those services that are not covered by the DMA. So again, well, you could say it's from the Bundeskartellamt's perspective, I guess it is really something. For them, it's really important. On the other hand, you might think that from the perspective of Google, first of all, it's really difficult to defend your position there, that, you know, efficiencies are so great if you can combine data only, you know, in regard to those services not covered or activities not covered by the DMA. And then on the other hand, maybe then also from Google's perspective, given that they need to implement the DMA, maybe it was not, you know, the price was maybe not so high. But I mean, my point I make here, okay, it's very preliminary, but if you think about this is like really like a relatively short time period. We speak about, you know, 2-3 years here. So the Bundeskartellamt has designated, and these are like, you know, huge designation decisions, designated 4 gatekeepers, plus they have closed 2.5 cases. If you compare that to what we, you know, saw in the last decade or last 2 decades in terms of like enforcement against digital gatekeepers, it might seem that like certain institutional design features here are really proved to be effective. And that's the point basically I tried to make, you know, in this last part of the paper.
So summing up this analysis and your investigation of different elements of the DMA, Section 19A, and other similar proposals, or maybe even legislation in some other jurisdictions, do you think we have many kind of black swans waiting for us juristically in the course of implementing these provisions and these ambitious regimes in practice, or things are rather more settled and you can already envisage the key development in the following years?
Well, that's a super difficult question, of course, right? So I don't really know. I mean, I don't really know. So I'm usually, when it comes to this kind of questions, I'm very cautious. So I really want to see the cases and then I make up my mind. So I propose, I mean, I would suggest indeed that if, you know, the moment we see really like contentious cases, meaning, so really like a gatekeeper stands his ground and saying, no, we don't want to change this, not at all. And be it under the DMA, be it under 19A, this is really, you got to watch that closely, and how, you know, how the institutional design mechanisms work here, how the authorities can make their case, how the courts will ultimately cope with that, all those challenges that might indeed be here on the road we don't see already. So I don't really know. I don't really know.
And the last traditional question, recommendation to students. You can draft it as suggestions for future topics examining these 2 regimes, or beyond, maybe which specific feature they need to practice, which would be of particular need for the market in the following years, or maybe some broader recommendation. Yeah, so.
Well, that's a tough question too, right? So basically, I mean, if you were, you know, watching this video to this point, I mean, you have proved already like a real like intrinsic motivation into these subjects. So that's already a norm, I would say. But so that's why I would rather go to like, I guess, like some 2 broad points. I mean, one is if you're a law student, but of course that applies to any other student too. I mean, there will be one point where you need to decide, you know, which way you want to go later. You want to be a lawyer. What kind of lawyer? You want to be somebody working for authority. Maybe you want to become an academic. Maybe you want to quit the law altogether. My recommendation would be, you know, follow just your gut feeling, because these kind of decisions are in reality so complex, so many parameters. There are some parameters you're not aware of, consciously at least. So really just follow your gut feeling. Of course, later you can rationalize this decision, or somebody else is asking, but just follow your gut feeling here. Because at the end of the day, to become happy with what you're doing later, it depends so much, you know, individual factors, your temperament, you know, how emotional you are, values you have, what kind of life you want to live. So really, just do what you think is good for you just intuitively. And the second point, I think, you know, whichever is your role later in, let's say, legal machinery or somewhere else, from time to time, not too often, I suppose, from time to time, it might make sense to step back a bit, to reflect on your role, and you think about what justifies your existence actually. Is this what you're doing good for the public good? Perhaps even in a very, you know, indirect way. So I'm saying this because that might be helpful to, you know, adjust your priorities in life from time to time, but also to, you know, to have motivation for the things you're doing.
Sounds like a very Kantian proposition. Jens-Uwe Franck, thank you very much indeed for this really informative, very detailed conversation. I learned a lot. It was a pleasure talking to you. Thank you.
Thank you.